stage next sitting day. Call on Government Order of the Day number 4.
Maori Purposes Bill, second reading.
Point of order, the Honourable Simon Power.
Mr Speaker, following the agreement of the Business Committee, I seek leave following the second reading of the Maori Purposes Bill for the bill to be divided into 4 bills as set out on Supplementary Order Paper number 270, and for the 4 bills so divided to be set down for third reading forthwith without debate.
Is there any objection to that course of action being followed? There is none. The Honourable Georgina Tahuhu.
Mr Speaker, I move that the Maori Purposes Bill be now read a second time. The Maori Purposes Bill brings together amendments to the Maori Trust Boards Act, the Maori Fisheries Act, the Ture Whenua Māori Act, and legislation affecting the estate of Puke Puke Tangiora. Part 1 of the bill amends legislation to remove Crown involvement in the administration of the estate of Puke Puke Tangiora. Following the passing of Puke Puke Tangiora in 1936, the life beneficiaries under her will made various petitions to Parliament for relief from the terms of the will. These terms were altered by Parliament through provisions in various Māori Purposes Act, but as a result, the Crown now has a more significant role in the administration of the estate than would otherwise be the norm. For example, Mr Speaker, trustees of the estate are appointed by the Governor-General by order in council on recommendation from the Minister of Māori Affairs, rather than by the High Court or the Māori Land Court. In recognition of the right of estate members to exercise control over their own affairs, the bill clarifies the jurisdiction of the Māori Land Court to appoint and dismiss trustees of the estate in accordance with the wishes of estate whānau, and to hear all matters relating to the administration of the estate. This is consistent with the Māori Land Court's jurisdiction in respect of other trusts over Māori land. Similarly, in 1943, Parliament removed the original will's requirement that all estate assets be retained in trust for 20 years following the death of the last remaining life beneficiary before being distributed. This bill therefore extends the trust period to 5 years after the death of the last remaining life beneficiary in order to give the estate whānau time in which to make decisions about a possible future governance entity to hold and manage estate assets. Mr Speaker, Part 2 of the bill amends the Māori Fisheries Act to enable the transfer of mandated iwi organisation status and fisheries settlement assets between separate entities operating within the same iwi. Should such a transfer be attempted at the current time, the protective provisions of the Act would require the settlement assets to be offered for sale to the highest bidder from other mandated iwi organisations and from Te Uhu Kaimoana Trustee Limited. This is clearly an unintended consequence of the Act. Allowing iwi to consolidate their fisheries settlement assets under a single entity will enable them to realise greater benefits from the management of their assets. The bill does not exempt iwi from the requirement to meet the provisions of any other legislation that may be required to effect a transfer. Part 3 of the bill amends the Māori Trust Boards Act to provide for direct accountability between trust boards and their beneficiaries. Present requirements for Māori Trust Boards to be publicly audited and accountable to the Minister of Māori Affairs for their financial arrangements are outdated and no longer reflect the environment in which trust boards operate. Instead, the bill requires trust boards to hold an annual general meeting to report to their beneficiaries on their activities and plans for the future, including the presentation of audited annual accounts, budgets and other information. The bill also provides that trust boards are to be audited privately rather than being audited by the Auditor General. Rather than charging the Minister of Māori Affairs with approving a trust board's annual budget, the bill now only requires the audited accounts and budget to be supplied to the Minister for his or her information only. Finally, Mr Speaker, Part 4 of the bill makes various minor drafting changes to Te Ture Whenua Māori Act 1993 and the Māori Incorporation's Constitution Regulations 1994. All of the amendments in this House, in this bill, are tangible manifestations of the National Government's commitment to a more prosperous future for Māori. They are important in supporting the increasing independence of Māori and the stewardship of their assets. Mr Speaker, I support the recommendation of the Māori Affairs Committee that the bill proceed without amendment, and I thank the committee for their work on this bill. I commend the bill to the House.
The question is that the motion be agreed to. The Honourable Mita Ruinui.